2006-48, and this is two different suggestions, motions for affecting the 2006-8 administrative order, deliberative privilege and case discussions in the Supreme Court. And Justice Weaver made the first of those two. Justice Weaver?
Okay, here's my proposed order, which I requested that be placed on today's agenda. The order declares and corrects the erroneous publication of AO 206-8, the gag order, declares and orders that AO 206-8 is and has been of no effect since January 17, 2007, and orders the cessation of any further publication of AO 206-8. Now, this is the proposed order. On order of the court, AO 206-8 is rescinded nunc pro tunc as of January 17, 2007. This court declares that AO 206-8 has been erroneously published. This court declares that AO 206-8 is and has been of no effect since January 17, 2007. The publication of AO 206-8, and by this 2006-8, I'll just call it I don't call it the gag order in the order, shall be ceased, and this order shall be published immediately by the clerk of the court. This order shall be published in all future editions of Michigan Rules of Court State. The order is based upon this court's review of its administrative records, wherein we find as follows. 1. AO 206-8 was immediately adopted on an emergency basis by a 4-3 vote. Voting in favor were then Chief Justice Taylor and Justices Carter and Martin. Voting against were Justices Kavanaugh, Weaver, and Kelly, with dissenting statements from Justice Weaver and Kelly as follows. During an executive session, it was adopted on December 6, 2006. This executive session excluded all staff, and AO 206-8 was adopted without notice to the public, and in fact without prior notice to some of the justices of this court. AO 268 was never subsequently retained or amended in accordance with this court's orders and procedures as set forth in AO 1997-11B2. 2. AO 1997-11B2 provides, unless immediate action is required, the adoption or amendment of rules or administrative orders that will significantly affect the administration of justice will be preceded by an administrative public hearing. AO 1997-11B2 further requires that if no public hearing has been held before a rule has been adopted or amended, the matter will be placed on the agenda of the next public hearing, at which time the Supreme Court will hear public comment regarding whether the rule should be retained or amended. 3. With required notice to the public on January 17, 2007, the contents of AO 206-8 were presented for public comment at this court's public administrative hearing. However, the records of this court reflect that later on January 17, after the public hearing was over, this court met concerning AO 206-8 and did not vote to retain or amend the order. Instead, this matter was, quote, passed to a later undetermined date, and no action on the matter was taken at that time. 4. While AO 206-8 was effective as an emergency order from the time of its adoption on December 6, 2006 until the January 17, 2007 public administrative hearing, this order was not thereafter properly retained or amended. To date, this court has not voted to retain or amend AO 206-8. Without any vote to retain or amend AO 206-8, it has erroneously remained as an allegedly effective administrative order in our court rules and on this court's website. 5. This court's records reflect that the file for AO 206-8 was closed on February 27, 2007.
Is there support?
That's my motion, that we adopt that order.
Chief Justice, may I ask some questions?
I just asked for support.
I support.
Okay. Yes.
As one of the co-authors of this, Chief Justice Kelly, I'd like to ask you a question.
Co-authors of what?
of the amendments of AO 2006-8.
I'm not
She
a co-author
didn't
of this.
author this. This is my authoring. I just checked the records of this court. Carefully.
It says on the schedule, with the proposed amendment from Chief Justice Kelly attached. What would that be
That's a
referring to?
This is not an amendment. This is the order I propose to correct
This
our
is a
records.
retroactive
Okay.
kill of the ordinance.
Separate
It's
from
not
that.
retroactive, it's not.
Let me direct the
because it
question
wasn't
to you
effective.
still, Chief Justice Kelly, as the Chief Justice. Why today are we considering this proposal, one that would retroactively amend an administrative order, an order that's been on the books for 4 or 5 years and that reflects the policy of every court in the country, as far as I know, from time immemorial? What is different about things today than things yesterday and last week and last month that cause us to be dealing with this thing under these circumstances? If this was erroneously published, as Justice Weaver indicates, and I don't believe that to be the case, but if it was, why didn't we take it up last week or last month or last year? Why today?
Justice Weaver has pointed out to us what she believes are flaws in the way this administrative order
These
was.
flaws existed last week and last month and last year. Is there something different about
Can I answer
today?
that?
I'd ask Chief Justice Kelly.
Oh, well, I authored it. It's okay.
From my
Excuse
point
me.
of view, we didn't know, I didn't know, that there were questions about the authenticity of this administrative order before Justice Weaver raised it.
So that's the entire context to our consideration of this, that we've just belatedly discovered that this was adopted incorrectly, and despite the fact that it's been on the law books of this state for a number of years, despite the fact that 10 million other people in this state presume that it's the full law of this state, suddenly we have to deal with this measure today in order to retroactively apply it back to when? Back to 2006?
It's not my motion, sir.
No,